Be seated. Again, good morning. Now is the time set for oral argument in cause number 1, CV 130370, Granville versus Howard. The proceedings are being both audio and video recorded, and they will be available absent some unforeseen problem on YouTube in a couple of weeks for everyone's review. Counsel, each side will be entitled to 20 minutes, and we would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. An appellant, if you wish to reserve any portion of your 20 minutes, as you did so well a few minutes ago, for rebuttal, please let us know so we can avoid taking up all of your time. However, as I stated before, ultimately your reserving of rebuttal time will be up to you. Again, we have reviewed the briefs and conferenced the case, so we are well aware of the facts and issues attendant to this argument, and please keep that in mind in addressing the court this morning. And again, counsel, when you come to the podium, please state your name and who you represent so we can keep the record clear. And with that, counsel.
Thank you again, Your Honors. I will attempt to save 5 minutes for rebuttal. Christopher Robbins on behalf of the defendant, appellant Vince Howard. Your Honors, I'm going to do something that I rarely ever do in a Court of Appeals argument and talk about the facts for just one moment. The parties were in a minor car accident in March 2008. In October 2009, the arbitrator awarded Granville, the plaintiff, a little more than $6,700. Howard thought the award was unreasonable and proved it to a jury in the trial de novo. In October 2010, the jury returned a complete defense verdict. Now, here's where I'm going to go off course a little bit, because obviously I've been thinking about this in preparation for this, and I know you have, and I know Mr. Abney has. But here's the answer that I believe, by any rational standard, the application of Rule 77F should have ended right there, and we should not be here.
But why is that? Because in Granville 1, the court found that the defense hadn't adequately disclosed important medical information, so you can't really hang your hat on a jury verdict where the Court of Appeals ruled the plaintiff was unfairly surprised.
But here's my point, Your Honor. That was the only appeal from the arbitration award. So if you compare, using again the express language of the rule, if you compare the judgment on the trial de novo, which was a 0 verdict, against the arbitration award, Howard prevailed and should not be ordered to pay fees.
That would have us ignore the second trial de novo.
No, I disagree, Your Honor, and here's why. Because what happened is the role switched. It's now Granville who's the appellant. And in fact, everybody admits that. He was the appellant to this court, and then rather than a trial de novo as to the arbitration award, we're now doing a trial on remand from this court.
But your analysis would have us stick Granville with the trial de novo result from the first trial that this court found was unfair, and vacated that trial because Granville didn't have notice of medical expert testimony that when he tried it knowing that, he prevailed. So I think this is a new argument that you didn't make before, but I'm not persuaded by it, because that would vitiate Granville 1's decision in this court. I mean, this court basically said it wasn't a fair trial for Granville.
Well, that's true, Your Honor. There was one undisclosed medical opinion, and the case was reversed for that reason. The situation, though, is that it's been flipped. I mean, what happened is the roles have been flipped. And if I could just one sidetrack, a case called Evenstad, and it's 178 errors 578. It says the application of a legal principle, and that's what this is, the interpretation of this rule, even if not raised below, would dispose of an action on appeal and correctly explain the law. It is appropriate for us to consider the issue, basically, even if the parties haven't raised it, because you want to get the law right. We've never faced this situation before, at least I'm not aware of any case in which the one party prevails at the trial de novo, then there's an appeal, and it comes back again. It's not a situation contemplated by Rule 77F. And so just using the express language of Rule 77F, let's look at the judgment on the trial de novo from the arbitration award and compare that to the arbitration award, and then everything afterwards falls by the side.
So the new trial basically doesn't become an appeal from the arbitration award.
Exactly. It's a judgment entered on the appeal on remand from this court.
What other arguments do you have?
Okay, let's move on. Obviously, you're not buying that.
What was your first clue?
Okay. It does go back for a new trial. The trial on remand from this court, and in February 2013, Granville squeaks by asking for and receiving a whopping verdict of $918.50.
But because the costs are greater, right? Therefore,
by any rational standard, if you were to ask any attorney or judge in this state, we would say Howard won not only the first trial, but also the second trial. So how was Howard rewarded?
But let me make sure, because I think Judge Kessler interjected something that's important. Mathematically, because of the taxable cost award, even though it was only a $918 verdict, mathematically the 23% standard wasn't met. Do you agree with that?
Yes, I agree, Your Honor.
Right.
But then doesn't it all become part of the reasonableness inquiry? And what should the trial court consider when assessing reasonable fees necessitated by the appeal? And maybe a $72,000 award on a $918 verdict isn't reasonable. But I think that's the more appropriate focus than trying to bootstrap punitive damage case law, because the underpinnings of punitive damage case law are completely different constitutionally. You have juries that award these verdicts, and I think State Farm versus Campbell talks about how arbitrary that can be, and how jurors are relying on evidence that's not really relevant. And it just seems to me the better focus under 77F is, was this a reasonable award in the context, not trying to bootstrap punitive damage awards that I couldn't find any authority for tying to 77F.
Okay. Well, just I have to disagree with one point that Judge Kessler made in the previous argument. These are positively sanctions. These are sanctions to deter and punish people who appeal from an arbitration award.
They're deterrents.
They're deterrents. They certainly are deterrents.
We can parse words.
Okay. Well, I will tell you that if I received a $918.50 verdict, and then I was told that the judgment against me is $86,646.40, I'm feeling punished.
Let's talk about that for a second. In your opening brief, I will suggest that in reading it, I sense the fact that you were a tad exercised about the opposing party coming in and simply, or what do you want to call it, minimally seeking $918 in their damages. That is a problem for you, correct? You not asserting the fullest extent of their damages, but only $918.
When have we ever seen that before? When has we ever seen a plaintiff come in before and say, oh, don't give me what I deserve. Don't give me even my chiropractic bills. Don't give me anything for pain and suffering. Don't give me anything. Just give me $918.50.
In the context of the trial, why would that occur?
Pardon?
In your estimation, in the context of the trial, why did that occur?
Because they knew they had run up the cost so high. Well, they had run up the costs so that they'd be qualified for the fees, and then of course, the fees are astronomical.
And this is clearly not something you're probably going to find in any decision, but I guess in some amount of language that's out there somewhere, were they gaming Rule 77 in the process of the amount of fees
absolutely. They had actually been hit with Rule 68 sanctions of approximately $17,000, and so they said, let us walk away from that. If you don't, we're going to suck it to you. And if we can get a verdict for even a penny, we're going to have so many costs that we're going to qualify for Rule 77F sanctions. And we're going to go out and increase those costs. We're going to take your experts' depositions. We're going to pay them expert fees. We're going to take other needless depositions. We're going to do everything.
We don't know if they're needless or not. But doesn't that go back to Judge Downey's comment about the reasonableness of the fees?
Okay. Well, let's talk about the reasonableness then.
Let's say you're the Court of Appeals and you want to give guidance to trial courts about reasonableness under 77F, sort of like Associated Indemnity does for 12-34101, a list of factors that trial courts should consider in assessing reasonableness. What are some of those factors? And you can tie them to how this case should have been resolved in your view if you want. But so what are the factors trial courts should look at under 77F? The amount in controversy, presumably?
Presumably, Your Honor. And obviously, let me say this. I really think there is a constitutional issue here. There is no limit on Rule 77F. Nothing.
You look. Many statutes. I was doing research. There are dozens, if not 100 or more, statutes that require trial courts to impose reasonable attorney's fees in various settings. So it's a time-honored, recognized standard. The question is, what is reasonable? And it seems to me that's perhaps the focus.
If we're going to talk about attorney's fees, then let's start where we usually start with attorney's fees, which is the fee agreement between the parties. They had a contingency fee agreement. What would be reasonable would be their contingency fee agreement. And
so
nothing
you're saying
more.
One factor would be what's the fee agreement between the parties?
Exactly.
And is that reasonable under 1.5E?
Yeah, I believe you're right, John. 1.5 anyway.
1.5, yeah.
Yes, so is that reasonable?
And in retrospect.
And in retrospect.
Because you have to use hindsight once you, okay.
So start with the contingency fee agreement.
If they're getting a 33 1/3% contingent fee, then on a $918 judgment they get $306.
Exactly. Or let's
factor. I don't think you can, because contingency fee case law isn't that narrow. A plaintiff's lawyer can collect a reasonable hourly rate, not with under fee shifting statute. So I don't think you could really say they're limited to $300, but it's a factor for the court to consider.
And I partly agree with Your Honor, but if we're going to really compare these to attorney's fees, then 12341.01B says it can't be more than the parties agreed. And if the parties agreed to a 33% contingency, then that should be the maximum. It can be less than that, but it shouldn't be more than that.
Contract versus tort is different, and I think you have problems strictly applying 12341 of case law to tort motor vehicle claim. But what are some other factors that you think the court should have considered that would have resulted in a very reduced fee award here?
Well, for example, first of all, anything on appeal, that was out. The $30,000 they want for appeal, that's out. Rule 77F does not provide attorney's fees for that. Why should they get attorney's fees for both trials and everything that's going on when they've basically set up the situation? It seems to me that maybe they get attorney's fees only for the second trial.
Sure. I'm not sure how that works into a factor.
Okay.
I mean, if we're trying to set, Judge Downey's premise was, if you're the Court of Appeals and we're trying to give guidance to the Superior Court, can you translate that into a factor?
The associated indemnity factors, I probably couldn't come up with better than that standing right here. Let's look at the merits of the case. Mm-hmm. If you asked anybody in this country who won the second trial, it was Howard. So obviously his case had merit. Could it have been resolved earlier? Well, neither party accepted offers of judgment. Either party could have accepted offers of judgment years ago.
Any efforts to settle the case?
I don't believe there were separate efforts to settle other than...
I don't mean in this case. I'm just
saying
that would be a factor.
That seems to me that's a factor.
If I heard what you were saying earlier, the concept that you would advocate is basically whether the attorney's fees became the tail wagging the dog, and whether there were fees incurred in excess of those that would have been incurred absent the prospect of a fee-shifting award.
Exactly. Yes, I agree with that. That's certainly a factor.
I consider that the bleak house factor.
The financial hardship. It's true my client was represented by an insurance company in this case, but if he got hit with any fee awards individually, it would have been financially devastating.
It's built into the rule already, because on motion the court can waive or reduce fees for
but
hardship.
There's a difference between thinking, okay, maybe they'll get $3,000 or $4,000 for fees, and getting hit with $72,000. I mean, $72,000 would probably take a big chunk out of almost anybody's life savings. That in and of itself is singularly unreasonable. The merits of has a case been tried before? This was a simple car accident case. It's been tried 1,000 times before. Would it stop anybody? No, it wouldn't stop anybody pursuing claims. They did what plaintiffs generally do. They found an attorney who would pursue the case under a contingency fee agreement. So all of the factors are basically, if they're either in favor of Howard or they're neutral. Can I think of others right here? And I apologize, Your Honor, I can't think of others just standing right here. It's just, if Howard had any notice, idea, any thought that he could possibly be hit with $86,000 in judgment for a $918.50 case, of course he would not have appealed. It infringes upon his right to a trial by jury. He never would have appealed, and no other party would ever appeal in that situation. We talked about chilling or freezing or trampling on the right to a trial by jury. This is it. If there is a case, if there is one of these arbitration cases that's going to be declared unconstitutional, this is the case.
I would think that if there were no parameters for an award of attorney's fees, like a jury award for punitive damages, then you might have an argument. But if there were parameters for reasonable attorney's fees,
but
always they were outside the constitutional.
But your Honor, always in the sound discretion of the trial court.
Of course.
And we don't entrust constitutional protections to the trial courts. Much as we respect them, much as they protect constitutional rights, you can't trust the discretion of judges. As much respect as I have for this court and the Superior Court, we don't leave constitutional protections. They are absolute. They apply to the rich. They apply to the poor. They apply across the board absolutely.
But again, okay.
Unless the court has any further questions, I will save my remaining time for rebuttal.
Thank you.
Thank you.
Good morning. May it please the court, my name is David Abney. I'm here representing the plaintiff, John Granville. First of all, I'd like to apologize for all the footnotes. I had an epiphany here a couple months ago, and I don't put footnotes anymore. I put citations in the text. There were an awful lot of footnotes. When I read that,
Did you read Judge Kessler's mind?
He was more than reading a mind. At the end of one oral argument,
I think you were in another oral argument when you heard me say that a lot of the judges really do not like those. And obviously we're more concerned about substance of the briefs, but it is very distracting to have all those citations and footnotes.
Counsel, that may have come up at an earlier point.
It terrified me, quite frankly. So
Through the state, yeah.
I don't do
wore
that.
An appropriate tie, so.
Yes.
So far, you're good.
Thank you for the good advice. I've reformed. And I appreciate the reference to Charles Dickens. This hasn't gone on for decades. It just feels like it. The first trial was done away with, vacated, gone. And so the roles are not flipped. They never have flipped. Howard is still the appellant from the arbitration, and it's like the first case wasn't there, except for the fact that the first case, quite frankly, terrified the plaintiff. Because they wound up at the end of the first case with the defense verdict and then all these nice sanctions, and came out $17,800 under a cloud of $17,800. So they had to appeal. They did the best they could on the appeal, and finally, they got a second trial.
Bleak House goes both ways.
Yes, sir, it does.
It can. I mean, I'm not saying in this case, but my experience is that good attorneys will make sure their clients resolve things before they get to this kind of.
If you can do it. And the letter that we put into, that was mentioned in the opening brief, and I put in my answering brief, that my colleague regards as an ad terrorem letter, wasn't. It's simply saying, this case is going to cost some, and we've got to do some depositions. It's going to take a little time, and we charge a fair amount. So if things go badly, think about what you're doing when you're appealing, because it could go south on you. And it wasn't blustery or anything like that. It was a very professional letter.
Well, it was professional, and it may not have been blustery, but it certainly was intended to provide notice.
Yes, sir, it was. Okay. And I hope it did. So after the first go around, then you get into the second trial. And toward the end of the trial, what happened was, if I may digress slightly, is at one point the defense counsel had indicated, well, there's we can say maybe $918.50 in chiropractic fees were justified. We can say that, but nothing else was. And so the plaintiff's lawyer, faced with a situation where they escaped by the skin of their teeth from the $17,800 problem with the first trial, they certainly don't want to have the roof falling on them again. So they got something solid to say to the jury. You should award $918.50. And of course that triggers some interesting things. In my brief, I said, we really shouldn't call them sanctions, but we do all the time, the same way we call motions pleadings. We're a little loose. I like Judge Jones' reference to it. He called it Rule 77 relief. I thought it had a very nice ring to it, or Rule 77 award. But the long and short of it was they were in a position that they could get out from under this and have a favorable result for the client.
Are you telling me that you didn't look at 77F going into that second trial and say, boy, based on our notice letter that's gone out and based on what we can assert as being this minimal damage, we could really clean up on a 77F award? No cleaning up. Not at that stage. When you're coming into the second trial and you got stung so badly the first time, you have a professional obligation to your client to do the best you can. Your client is it could be facing another $17,800 plus a whole bunch of other stuff added on top.
Why not just try to settle it? Why not, when the defendant comes in and says, okay, there's $918, why don't the parties make a good faith effort to settle it right then and there and avoid all of the attorney's fees and the sanctions, and in the interest of the client, get rid of it rather than having the fees wag the dog. That's a mixed metaphor, but having the tail wag the dog.
And can I add on before you answer that, because I seem to recall on the record at one point Granville offered to walk away with nothing if.
Yes, there were discussions. There were discussions of that nature, and they bore no fruit. And they should have. It would have been a good way to do it.
Do you remember where in the process that occurred, that offer from Granville to walk away with nothing?
It was after the appeal. I mean, the appeal to this court. Yeah, it's, and appellant, of course, is used in two different senses in this case. We've got appellant here and appellant, and I think that maybe inspired my colleague to to his flight.
And so if we get back to the reasonableness of the fee award, those are factors that a court could determine in determining the reasonableness of fees, because they could say what settlement offers went on, and what were the parties' position on settlement, and that often happens.
We would come out okay on that.
No, I'm not saying whether you come out okay or not. That doesn't. I mean, the point is that would be a factor the court could look at in trying to determine the reasonable fee award.
Yes, Your Honor. And the overall amount. I think this isn't the similar case still China Doll, or is it called something else these days?
Dwyer versus China Doll.
Dwyer. Okay, so China Doll. All right. And there's all those factors that are listed there: the competency of the counsel, the risk involved, the number of hours. All of those things come together, and that's what the trial judge does. And the trial judge is in a very good position to do that. Knows the parties, knows the case, has the presentations from the counsel, and is able to come up with what is reasonable. And it's as Judge Downey said, there are dozens of statutes. And if you include federal statutes that might affect Arizona, there's probably hundreds where reasonable attorney's fees and costs can be awarded at the discretion of the court. And courts do this all the time without any constitutional problem. It's not a punishment, it's an assessment of the time, effort, and cost that went into the particular case.
And reasonableness has to be tied to something. And I know in your cross appeal you would ask that you receive about $140,000 in fees in a case that generated a jury verdict at plaintiff's own request of $910. And I have a hard time with that. Tell me why in any theory that would be a reasonable fee.
Number of hours, competence of counsel, and the result that you got. And my cross appeal is not my finest appellate effort, quite frankly. Christopher Robbins called it embarrassing, and it's not embarrassing, but it's close. It's a good faith effort, though, to try to spend something worthwhile here to reach the full result. And the major argument of the cross appeal is that they provided no concrete counter evidence to the evidence that was provided to support the requested attorney's fees. That's a very slim argument, but at least it's a good faith argument, and I'd rather talk about the rest of the case if I could.
Do you have any recollection of what your fees were at the end of the arbitration?
No, Your Honor. Offhand, I don't.
So you wouldn't be able to break it out as to what the fees were that were incurred in arbitration, what fees were incurred in the first trial, and what led up to $140,000.
Oh, certainly. Yeah, that was provided in affidavits and breakouts to the court. You could go back and say, at any particular time, you could calculate what it was. Sure, you could do that. But in this case, there's no effort at all to pump up things. It just takes a lot of time and effort to deal with an arbitration. Then you have a jury trial, 3 days. I mean, it takes a lot of work even for a 3-day trial to get ready and to do it. And then you've got an appeal, which takes time and effort. Then you've got another 3-day trial. But that's a lot of time and effort that goes into these things. And it just, it isn't exactly the tail wagging the dog in this case. It's close in some senses, but it simply takes a lot of time and effort. And if you do that on an hourly basis, which I believe is justified, then it adds up. It's unfortunate. Lawyers come over here all the time from the AG's office, and they obtain attorney fees results for the government. They do it at the Superior Court. And at the district court, lawyers come over from the U.S. Attorney's Office and they win cases, and they're awarded an hourly rate, even though they're not paid by the hour. The court devises through presentations to it what is the hourly rate for this kind of work in the community for these kinds of lawyers, this kind of case, and they award the hourly fee. So I think it's not just that there's a contingent fee out there. In a case like this, a contingent fee doesn't really capture what Rule 77 is about.
But it could be a factor.
Absolutely, it could be a factor. And I hope it's a factor the court looks at it and says, well, you know, it leads to an absurd result in this case because certainly with some law firms, about an hour of your time you've burned up the contingent fee for the 918. But the rule itself talks about the reasonable attorney's fees as determined by the trial judge for services necessitated by the appeal. and there were a lot of services necessitated, including the appeal up to this court. I don't know why that's carved out as something that you can't get attorney's fees for, because it was necessitated by the appeal from the arbitration to the Superior Court.
Well, but I think that Jaroszczuk case basically says exactly that. It was under the Uniform Rule of Procedure for Arbitration 7F, which was different in that it was only 10% more favorable. But they said that it did not include fees incurred in the Court of Appeals from a trial de novo, from an arbitration appeal. So it seems to me that's the same under our rule. But the secondary reason I think it's a problem in this case is it's the appellate court's role to award attorney's fees or not in an appeal, and there was no request in Granville 1 for attorney's fees.
No, there was not.
And so we sometimes let trial courts include fees incurred on appeal on remand, but we didn't do that here. And so the Superior Court can't determine what reasonable fees were incurred in Granville 1 and award them, even setting aside the Jaroszczuk case. So to me, that's a pretty clear issue that they cannot be included in the trial court's award.
I was hoping that the passage of time would bring enlightenment on that issue. But in any event, I've made the best argument I believe I could make on that particular point. But even if you cut that out, we are still entitled to the benefit of the general doctrine that trial courts try to follow the law and do follow the law. And surely some of the fees that were cut off from the original amount that we requested at the Superior Court would include the fees up to this court. So the $72,000 can remain.
Yeah, plenty of time. So I'm interested in policy considerations because clearly the impetus behind 77F is to discourage appeals of reasonable arbitration awards. But there's got to be something on the other end of the spectrum. If an appellant from an arbitration award acts in good faith, it seems that at some point it becomes very punitive to require them to pay. I don't even know what the multiplier is here. Well, it's about 72 times the amount of the jury verdict.
If I remember my colleague's math, it's higher than that. It's somewhere 100 some odd.
I'm not good at math. So.
Me neither are.
But there's got to be some policy consideration that attaches at that end of it too, because otherwise this becomes, even if I don't agree with Mr. Robbins of constitutional dimensions, it becomes excessive and unreasonable by any definition. So I'll pose the same question to you as I did to him. What other factors should trial courts consider? If we want to advise trial courts about 77F and what factors into the reasonableness, what other considerations would you suggest?
I would say positive evidence of overreaching, if you can find something like that in the record.
By either side?
By either side.
Either to churn fees or by a richer appellant who wants to coerce settlement or just outright capitulation.
Right. And then protection of the client should be a valid consideration. Here the second trial, was a way to protect our client because we had to do better than we did the first time, or they would face even higher. We already faced potential $17,800, even higher fees than that. So protection of the client should be some consideration in this. I think we talked about good faith, and a consideration of the China doll factors. How did the trial judge consider those factors, one way or the other? I think that would help trial judges understand what they need to do. It might also be good to say we need to have some findings of fact and conclusions of law on this issue, because right now I don't think there's any requirement for that.
Yeah.
And with all those things, yeah, if you put all those things in together, this case could be a positive for the trial courts. But from our perspective, it's not overreaching. We're simply trying to protect the client and dig the client out from under this burden and turn something bad into something good.
Tell me about the burden. A minute ago you said something about the fact that the second trial was essential because you needed to protect your client.
Well,
the onerous implications of
there were offers of judgment already out. I mean, if we didn't, we might have been penalized if we didn't succeed by the offers of judgment.
Rule 68 problem.
Right, Rule 68 problems. And then in the background, we had the difficulties that we got costs, attorney's fees, and another adverse judgment we thought we might face. So when they come down to the end of the second trial, it appeared that there was a way to get out from all of that by simply asking for basically what the defense was saying was okay, the $918.50. It's done in the context of a trial. The plaintiff's lawyers thought they had a pretty good case, and that the first case was an aberrant result, and that they should have gotten at least, the chiropractic bills, if nothing else, which is what the arbitrator essentially awarded. And when it came down to the end, they were going to ask for the chiropractic bills and nothing else, and all of a sudden they got an opportunity, an actual hard figure they could argue to the jury. Well, even the defense says $918.50 is okay. So they asked for that with some assurance that they would get it. And when they got it, things turned out very well. It's good lawyering. I'm very happy with these guys. Yes, sir. But these are good lawyers. They did a very good job and turned something potentially a disaster into something very good for the client.
Well, yes, because the client avoided the attorney's fees from PIO, from the arbitration award, but the parties that really made out were the attorneys. They came up upwards of $72,000 in attorney's fees.
The custom
client sitting there saying, "Hey, I avoided Rule 77 fee award, and I got $900."
The custom in these cases, which is followed, if I may talk about just general custom, the custom in these cases is pretty simple. You don't keep your attorney's fees award. You take a third, and the rest goes to the client. That's just the custom. You don't have to do that, I suppose, since it is an attorney's fees award. But you'd feel awfully stingy and cheap if you gave the client $600 and you kept the rest of all this. That'd be bad, very bad.
I can see a new sign going up on an office in town: stingy and cheap.
Yes, and we try not to be. I mean, and I know that my colleague was a bit exercised in his briefing. It's unusual for him. He's a wonderful professional, but this was not an effort to cheat anybody or to take unfair advantages, trying to get a good result out of something that had so far not worked out very well. If there's no further questions,
Thank you,
I
counsel.
will give my time to the court then. Thank you.
Just so you're not in the dark, Mr. Abney wore a Mickey Mouse tie one day to court, and I commented on it. So.
It's subtle, though. That's okay.
I just didn't want you to feel in the dark.
Your Honors, just one thing about constitutionality. In other states, in the cases cited in the previous appeal, one said there's you can recover arbitrator's fees up to $1,000. Another said attorney's fees up to $5,000. If this rule said that, we're not even here. Mr. Granville would never have been subject to attorney's fees because, according to what everybody's saying, he was the appellee throughout this. He would never have been subject to attorney's fees. Judge Downey, you were exactly right. This was an appeal of an unreasonable arbitration award, and we proved it twice that it was unreasonable, and yet we're still sanctioned by $72,000.
Well, and it seems to me that could be a relevant factor. Was it a reasonable appeal? And if not, then perhaps the sliding scale of fees is increased.
They talk about they were taking risks by asking for a small amount of compensatory damages, and that the risk paid off for them. Well, it didn't pay off. It didn't pay off for Granville. It paid off for the attorneys, just as you noted, Judge Kessler. They say, no problem here. We would never send a $143,000 bill to a client for a $918.50 verdict. We only send that to the wealthy insurance company. The Arizona Supreme Court rejected that practice in In re Schwartz, another factor to consider in the reasonableness. Your Honors, we all know that this was an unreasonable award, and I'm not quite sure what Your Honors will do. Certainly somebody needs some standards, but it needs to be something more than just the bare discretion of the trial judge. There has to be some standards to guide the trial judges if they're going to be applying Rule 77F. And I thank you all for your time.
Worked out perfectly, counsel.
Used exactly the amount of time.
Exactly. All right, counsel, thank you. We do appreciate oral argument. It's interesting for us, and it certainly raises issues and addresses issues in a vein that we may not get from the pleading. So thank you for that. We are under advisement at this time, and a ruling will issue in due course. So thank you.